Hello and welcome to the Financial Puzzle Playbook with your host, Jim Sumter. I'm RJ Malik, producer of the podcast. So, we've been talking about the 6 puzzle pieces on this podcast. And, Jim, you've got another piece to the puzzle. So, why don't you give us a little preview of what we can expect on this podcast?
Well, RJ, I definitely will. So, one of the things that we always talk about as we go through the 6 puzzle pieces is I always talk about estate planning sort of as the last piece. So we're going to jump to the end today. We're going to go to estate planning and we're going to talk about the basics of the who, what, why of wills, powers of attorney, medical directives. We're going to jump into to some basics and then get a little bit deep. And I have with us today a dear friend of mine, Alex Priester, who is an estate planning attorney with Dominic Feld and Hyde in Birmingham. So, Alex, welcome to the podcast. And why don't you give us a little bit of your background?
Absolutely. First of all, thanks so much for having me. Like you said, it's taken a little bit to come into fruition with schedules. And actually, my twin girls just turned 1. So that's a big part of my background, but also a reason why you haven't seen my face quite yet. So I appreciate you having me today. So as far as my professional background, I attended the University of Alabama for law school. I was actually right smack in the middle of COVID, the COVID graduating class. So I'm just very privileged to be able to talk to you face to face today without a mask, without restrictions. I've been practicing in the Birmingham area at Dominic Feld Hyde in their estate planning group all the 4 years that I've been out of law school. Actually, in law school, while I got my JD, I also got my LLM in taxation. So I have got a lot of clientele who come to see me for estate planning. Lots of people who are interested in the taxation of estate planning, small businesses, corporations, all the things that you could possibly want our firm takes care of, but I like to be a small part of that.
That's awesome. Well, Alex, so I'll tell you, so two quick things before we jump into the questions. So first of all, you were in law school during COVID.
Yes.
My oldest daughter, Madison, was in medical school during COVID.
Bless
So
her.
we have a lot of professionals
Yes.
that are that learned during that period of time.
Yes.
Secondly, I'll just mention, this is kind of interesting. So you mentioned the LLM.
Yes.
My master's in taxation is an LLM equivalent.
Right,
so
right.
a lot of times you and I have these really deep, nerdy discussions
Yes,
about
which I love.
that we get super deep on things.
Right,
We are
right.
not going to do that today.
Absolutely.
We
We'll
are
lose everyone.
we're going to, those are way down the road
Exactly,
podcasts. So
exactly.
what we're going to do is we're going to talk about the basics.
Sure.
Okay. Of what is estate planning, because everyone's heard of estate planning, everyone's heard of a will,
Exactly.
powers of attorney. A lot of times you think, well, do I need that? Do I not need that?
Right.
Take us through what is actually a will and
Sure.
why is that important?
Absolutely. That is one of the things where I have people come in, they think they know what they need, which is great. I love that you have even picked up the phone. So what I tell people when they first come to meet with me is there's really no such thing as a dumb question. So I always try to gauge, what do you know about estate planning? And one of the things that really surprises me, and I've just no judgment on my end at all, because I grew up with an estate planning mother. She's an attorney in Huntsville.
Right.
So I'm familiar with that lingo. I don't expect anybody else to be familiar with that. So, but what I'm finding is that most people, they've heard of a will. They know they need one. They know enough to pick up the phone, but they're not really sure exactly how it fits into their lives, when they need it, why they need it. They just know that they do. And that's one of the things that I am not comfortable, just like I'm not comfortable with if I were to go purchase a car, with somebody sending me out into the world driving a car I know nothing about. I want you to understand, why do you need a car? Why do you need this car? Why do you need this car over that car? So that's how I feel is a will. It's a mode of getting you somewhere. So what is a will exactly? A will is basically, taking it down to the barest bones, it is the blueprint for passing on your estate. Now, what is your estate? Your estate is going to be all of those things that you own at your death in your name alone, that do not otherwise have another owner. For example, joint tenants, right of survivorship, things like that, how you own your real property, or maybe your brokerage
So,
account.
so what you're saying is if I own my house with my
Yes,
wife,
with your wife, right?
then I don't own that outright because I
Correct.
own it with my wife.
That's
I own
correct.
that jointly.
Exactly.
Okay.
So your estate, we plan for both situations because we never know when somebody's going to die first, second. So we act like the things that you own are going to be a part of your estate, because if you were to own your house with your wife and you were to pass first, your wife would inherit that house without the need for your will to be involved. But should the worst happen in the other situation, you don't know who's going to pass first. So that house may be part of Jennifer's estate, it may be part of your estate. So we try to plan with all of the kind of alternatives in mind. So your will handles those things, like I said, that are a part of your estate, those things you own individually, those things that don't have a joint owner that otherwise would need to pass through probate being the vehicle to get them ultimately through where you need to be.
And we're
and
going
where
to
you
talk
want them.
about probate in a
Exactly.
little more detail in a
Exactly.
minute. Yeah.
Because there's a lot to it.
There's a
and
lot to it, yeah.
it can be kind of a hairy subject, but hopefully we're going to show people it's not that bad. I mean, it's really, it's more complicated than just, it's nothing, but it can ultimately be more user friendly
Okay.
than we think it is.
Okay.
So your will is the vehicle that drives that whole probate experience. It's the blueprint document for that. And also, we're going to talk about this too. A lot of people do not realize that your will in Alabama and some certain states too. I will give the caveat, I'm licensed to practice in just Alabama and Tennessee, so I have to legally say, that's where my expertise
Okay.
resides.
Okay.
But as far as accounts and things that you're familiar with, like life insurance, your brokerage accounts, your 401ks, those all have beneficiary designations. Your will does not override your beneficiary designations. So the things that are a part of your probate estate, again, and I know I keep repeating this, they are the things that do not otherwise have an owner. So own jointly, which would be like a house and other certain types of accounts, or also accounts that you've got an otherwise named beneficiary on. So you could be looking at your estate consisting of as many things as you think or very little at all, which is one of the reasons why when you sit down with an estate planner and you're preparing your will, and people ask, why do you need copies of my deed and copies of my bank accounts and copies of XYZ, all of those things that you get from an estate planner, those requests that say send over all these things. Your will encompasses all aspects of your life. Like one of my law partners said, it is the biggest business transaction you will ever conduct because it is everything that you own.
Wow. Okay. So let's start breaking that down a little
Absolutely.
bit. Okay. So when I did, I believe it was podcast episode number 3, I talked about cash flow.
Right.
And one of the things that I talked about were different phases of life. So there's the wealth accumulation phase, which is maybe somebody in their 20s or 30s. They're starting out, they're beginning to accumulate some wealth. They have children, just starting out with life.
Sure.
Then we're in the wealth preservation phase. That's the phase that I'm in. I'm trying to preserve what I have. The kids are out of school. And so I'm trying to preserve and still grow assets, but really paying attention to, hey, unfortunately, I'm closer to retirement than starting my career. Let me say that. So that's that phase. And then the third phase is when you do retire and you start distributing assets.
Right.
Okay. So from a financial planning standpoint, those cash flow phases, there's also those same phases in estate planning.
Exactly.
Because a lot of times when I meet with a younger couple, let's say, late 20s, early 30s, got, maybe they have children, maybe they want children at some point.
Right.
A lot of times they'll say, well, Jim, I don't really need a will.
Sure.
Do I?
Sure.
And so that's the way the question goes.
Right.
I don't really need a will. Do I? So I'm going to ask you that question. Right. Does that person need a will?
Sure.
Okay. So what are some reasons why they would?
Exactly. So the biggest thing is going to be twofold. Okay. If you can automatically answer me these two questions with a yes, you need a will. The first one is, are you married / have children? i.e., do you have immediate family members other than your parents, siblings, things of that nature? things, family members that you are kind of your dependents that you would want to take care of immediately.
Okay.
So if you've got a spouse or you've got a child, more than likely, yes, you're going to need some sort of will. And that is because your will can also encompass not just what happens to your things, but how you want to take care of the people around you. For example, in relation to children, one of the very most important things that we can put into a document, a will document, which is called a testamentary instrument. And I say that because that's the language under the code that allows us to do this.
This is one of those technical terms.
Yes,
we're
one of
not
those
supposed
technicals,
to
those
use.
$5 terms. Yeah. So a parent can use, or a spouse
Okay.
can use a testamentary instrument
Okay.
to name a guardian for either their spouse, which is not as likely when you've got, a 20-year-old, a 30-year-old, but things happen, illnesses happen.
Sure.
Or your child, your young child who is under the age of 19, to serve as guardian for them at that point.
Okay.
That means they get to essentially skip all of the heartache, the time, the expense of going to court and attaining a formal guardianship. They can file that instrument in the area, the region, the geographical area that minor or spouse lives, and be able to essentially walk right into their responsibilities as guardian for that individual.
Okay. So does that mean, because a lot of times I talk to people about, who do you want to be the guardian for this child?
Right.
So that's the person that can enroll them in school,
Exactly.
that can do things with their medical doctors
Right.
and things like that.
Right.
Then there's the side of the money.
Right.
Who is actually in charge of the money?
That's
Many
correct.
times that's
Right.
the same person.
Exactly.
But occasionally those people might be different.
Exactly.
Is that true?
That is very true.
Okay. So does your will spell that out?
So, for example, your will spell that out differently than your guardian's will.
Okay.
Because your guardian, as the parent or spouse, and I keep saying spouse, but it's easier and more familiar to talk in terms of a child.
Right.
Because nobody likes to think about something happening to your 20-year-old spouse.
Sure.
But it does encompass that. However, when you're looking at making someone a guardian, a parent is a natural guardian for a child. A parent is actually, which surprises most people, and it did me when I started practicing law, a parent is not a natural custodian of the child's money. So, for example, if they inherit money from a grandparent, that grandparent is probably, if they've done a will with an attorney prepared will, not just like a rocket lawyer will or something that they haven't had a professional look at, then that will is probably going to have a vehicle for them, such as a trust, which allows the child to have that money because it is legally theirs, but to have another responsible adult in charge of that money until a certain period of time. Now, guardians are not going to have that natural, we're taking over their money, because that, like you said, that's a separate role. Guardianship is the care and custody of the child, the decision making, the physical placement of the child, the healthcare decisions. The custodianship or the trusteeship or whatever vehicle you use in order to place those funds with the child, to act on behalf of them as their custodian for that money or their trustee for that money, that is a separate role, which you can wear both hats. And oftentimes people do. If they're physically living with that person, they're probably more familiar with they need dance lessons, they need soccer practice, they need tuition for school. But it doesn't have to be. And I tell people all the time, separate roles mean we need to have separate discussions. They don't have to be segregated, but you need to think about them differently. Even if they end up being the same person, they are different roles and different hats with different responsibilities and operate differently under a will or whatever testamentary instrument you use.
This is interesting because basically what we're saying is if you have a spouse, if you have a child, you need a will.
Right.
Okay. And there's reasons why you do. I think part of what, I want to try to get across here is that it's important. There's people that can help quarterback all of this. That's
Right.
my role as a financial
Right.
planner, your
Right.
role as an estate attorney,
Right.
and us coming together, because we've worked with many, many clients together.
Absolutely.
And what's interesting is every single one of them have a different fact pattern and a different set of circumstances.
Always.
And so a will is not a cookie cutter
Never.
something.
Right.
Okay. So
Right.
let's move on to the next phase. Let's
Sure.
talk about me.
Absolutely.
Okay. So or my age, not
Right.
talk about me, but
Right.
my age.
Yes.
So I'm 10, 15 years out of retirement. My kids are out of the house.
Right.
I do have one in college, which we're going to address something in just a second, which I have recently learned. After a 27-year career, I can still learn things.
Absolutely.
And but my kids are out of the house. So,
Right.
so my kids are also considered adults.
Right.
So my documents do not necessarily need guardianships.
Right.
Okay.
Correct.
But what are some different things that my documents might need, or what are things that I might want to make sure from a beneficiary standpoint,
Sure.
things like that?
Sure.
How would I in my age want to make sure all my things are buttoned up?
Absolutely. So for my 20-year-olds, my 30-year-olds, people in my age demographic who have just started, they're coming into their careers, they're paying off their student loans, don't have a lot in as far as net assets. Your will is going to, like I said, focus primarily on your loved ones and taking care of them and making sure that the vehicles that you have, minimal assets that you've got, transfer over to those young persons or vulnerable persons in the best way possible.
Mm-hmm.
So we're looking at essentially a protection element for those people. In your area of life, where I call it the peak area of your career, where you know where you are, you're established, you're only growing from here, you kind of know what your goals are as far as what you want the rest of your career to look like, but you also have enough time for there to be major legal changes, major personal changes. There's lots of time before and after where you are in life. So your documents aren't necessarily going to look at protecting your loved ones as far as guardianship or things of that nature. You're looking at protecting your loved ones where they're at, because at this point your kids, the financial managers they're probably going to be. They're looking at possibly dating romantically and looking at partners, and you kind of know maybe if they're planning on having, this type of career versus that type of career. So when I'm doing a document for a 20-year-old, a 30-year-old, if they've got children, we're probably going to build in something. I have no idea how my 1-year-olds are going to manage money. So there's going to be a lot of changes to those documents as I learn how my kids are and who they are and meet them. You kind of know your children and how they're going to handle if they were to get an inheritance. So for you, it would be more of not simply setting something up that we hope is better than nothing. We've got something that's going to help pass wealth on. So you've got assets that aren't being used to, hopefully at this point, to pay off student loans, things of that nature. So you've got money that we can have a conversation about where we take those assets and help them grow, help them stay, available to your loved ones. You can have talks about, well, in the next 5 to 10 years, these are my plans. What I tell people in this demographic is at 20 to 30 years old, coming in that you can't tell me what your life looks like when you're 70. At 50, 60, you're looking at people who feel pressured to tell me what they think their life's going to look like at retirement or post-retirement. So many of the conversations I have with people in this generation are, it's okay. You're going to come back and see me in 3 to 5 or at maximum 10 years. We want to plan for you right now, because we are looking at what your life's going to look like in the foreseeable future, because you're not dying anytime soon, knock on wood.
Right. Hopefully.
Hopefully, exactly. So you are going to have documents.
But if I do, I have a will to
exactly.
take it. Yeah,
that's
right.
Exactly right. Plug. You've got a document that's got not quite as much ambiguity as somebody with a 20 or 30-year-old. It's going to have more solidity to it, but it's going to still have that level of flexibility to build in for the wealth that you anticipate.
So you said something interesting. You said that I'm going to come back and see you in 3 to 5, 10 years max.
Yes.
So what you're saying is,
yes.
Once you create a will,
Yep.
it needs to be reviewed.
Exactly.
Okay.
Yes.
So let's move on to the last stage real quick,
Let's do it.
I want to talk about a couple of other things. So
Sure.
the last stage is I'm retired.
Right.
Um, the you know two things I can guarantee you. Number one, tax law is going to change.
Exactly.
And number two, you're going to die at some point.
Exactly.
Okay.
Exactly.
And I should say tax and estate law,
Right.
because we've all seen that as well. So, as things change, as
Yeah.
things evolve, maybe you become widowed, maybe you have a medical
Right.
issue,
Right.
things like that. Does your will need to be reviewed in those latter stages of life as
Absolutely.
well? And maybe
Absolutely.
what are one or two changes that you see in your practice where maybe that age demographic needs to make some adjustments?
Sure. So we've talked about 20, 30-year-olds protecting vulnerable loved ones. You die at that point, you've got a little bit maybe to give to them. In your stage of your life, you've got a decent amount that you could leave to them. In the latter stages of life, in that latter stages of retirement, when you're looking towards the end, what you're going to find is that we might be looking towards the possibility of having little again. And that could be because of the exorbitant amount of long-term care costs that we see eating estates. Now, at that point, I'm not trying to scare anybody. What I tell people is this: I am here for you. You're my client. If you spend your last penny in the gumball machine at the nursing home, we've done okay. That's perfectly fine. That means you're cared for. So we've gone from thinking about the altruistic at that phase. We've got young kids, we've got young spouses. We want to make sure they're okay. To now, my kids are established and they're adults. And if I leave them at this point, hopefully they're going to be all right.
Okay, so Alex, we've talked about a lot with regard to will. A couple other things that do come up from time to time is if someone has lived in a community property state,
Right.
That brings on a new set of nuances.
Right.
The other thing that we see a lot of times is people that might own assets in multiple states. Maybe they inherited a second property, they own a beach property, they own a mountain house, things like that. Are those things that need to be addressed?
Absolutely.
In the wills? Okay.
Those are things that they are, and because you warned me and said, Alex, we need to keep this basics. We're not going to go 2 hours.
That's right. That's right.
These are things that automatically we have a questionnaire we have clients fill out at the beginning. It just is a get to know you. These are two important questions on there, and they are highlights where we have a more in-depth conversation. They don't necessarily add time and expense to your will, your estate plan, but they are things that, for example, when you go into a meeting with an advisor, you need to have conversations about. So if you know that you've lived in a community property state in the past, lots of military members have, or if you know that you have or stand to inherit, will have or have, then you need to, those are just things you need to bring up because they add nuance to the conversation.
Right. Okay. Well, and that's why I wanted to bring them up, because as a financial planner, that's on our questionnaire as well.
Exactly.
And then we move on.
Right.
Okay. So we've touched on will.
Right.
There's 3 documents. There's a will, a powers of attorney, and medical directive.
Sure. Yep.
Let's hit power of attorney.
Let's do it.
So will is basically what happens to your assets when you are deceased.
Correct.
The power of attorney is what if you are still alive, but incapacitated?
Correct.
Is that in a general sense what a power of attorney does?
It is. And I'll add one caveat to that, because it helps to show people exactly, even though you deal with this every day, there is a nuance to that a lot of people aren't quite aware of. So with powers of attorney, I break this up, and it's a little crass, forgive me, but we break them up into our death documents and our dying documents. So our death document is our will. Our dying documents is kind of a misnomer, because your advance directive and your power of attorney don't necessarily have to do with when you're incapacitated or dying, but are most important generally in those situations. However, there's 2 different kinds of powers of attorney, and I recommend actually one over the other, and it may be surprising what my recommendation is. So a power of attorney, that is a document that allows somebody to transact business on your behalf. So there's the healthcare component, which is your advance directive, your durable power of attorney for healthcare, that type document. And then there's the financial power of attorney. The financial power of attorney is what we're talking about right now. That document allows somebody to get your bills paid. They are able to change beneficiary designations if you so wish for them to do that. People who are your elderly clients, I'm sure that they've got powers of attorney on file with you that allow a child or a spouse to come in and manage accounts, have those discussions with you, file your taxes, things of that nature. Now, I also will tell people that it is not only when you can't do it, it's if you don't want to. There are lots of things that come into your life that allow you to. Let's say you're going to Cabo and you, crap, I forgot to pay my mortgage. Most of it's online these days, but things happen. You change cards, you change accounts, things of that nature. Your power of attorney, and this is a power of attorney that most people have. It's called a sprung power of attorney. It's a weird word, but there's a springing power of attorney and a sprung power of attorney. What I'm talking about is a sprung power of attorney. That is a document that it's the same thing. It allows somebody to transact business for you, but it allows that person to do it without the need for a formal declaration of incapacity. I recommend that, and that may be surprising. They say, don't wouldn't that allow somebody to come in and potentially wipe out my accounts? Well, theoretically, but why would you name them
Right.
if they're going to be doing that? You want to name somebody you trust to perform these actions for you. So the reason I suggest sprung over springing is that you don't want to have to, when you need your power bill paid, when you're in the hospital after a car accident, I'm using that example because that could happen to anyone at any age. You don't want to have to then have a doctor write a letter of formal declaration of incapacity, because you may not be incapacitated at that point. You just can't get down to wherever place you need to go. What if it's April 13th and you need to go see your accountant? You're not incapacitated at that point. You've got a seriously broken leg. So you wouldn't be eligible at that point if it's a springing power of attorney that requires a declaration of incapacity for that document to be used on your behalf. So lots of people who, for example, if you've got, great Aunt Sue who is preparing her power of attorney, she's 90, she's got all of her loved ones have passed at that age. She only has her neighbor, her church friend to be able to appoint. At that point, we may want to look at having a springing power of attorney for her, because neighbor she may be the only option at that point. But if you've got your name and your spouse or your child, why would you want that impediment there that's only going to make your life more difficult? So like you said, it is a document that you can use if you've got incapacity, but it's also something to make your life easier.
Okay, so that's interesting, and something that you brought up to me a while back. We were working with a client,
Mm-hmm.
and this is actually my personal situation.
Sure.
So I have Cassidy, who is
Yes.
20, and
Yes.
Cassidy's in college.
Yes.
And then Madison is 27. She's not married. She is a physician in Illinois, a long ways away. Would they need a power of attorney, and would I be that power of attorney for them? Let's kind of talk about that real briefly.
Absolutely.
Because this was
Sure.
very interesting to me the first time I heard it.
This is a document that if I have someone who's freshly out of the house, has no assets, has no loved one, has no children, this is the document I say, if you're going to have nothing else, please have this one. Why? Well, I only have one account. I have my checking account, whatever. I will tell you, this is a very important document, because this is a document that not only allows this college age individual to have someone with access who can help them navigate their liquid funds. This is a document that will also allow parents who may be paying or funding the college experience to have access to student records. For example, the law, FERPA, we're just going to call it FERPA and not go through the whole acronym, basically says even if you're bankrolling your child's college education, you have no right to see their grades, how they're doing, where they live, where their dorm is, all of that, because of FERPA. They're adults at that point. There is a section you can put in a power of attorney that says, I'm giving my agent access under my power of attorney to allow them to see these things. Because I will tell you, at 19 years old, I didn't know how to rent a textbook. My mom could have then signed that contract for me as my agent under my power of attorney.
So does it also mean, God forbid, something happened to Cassidy,
Right.
and she were to she's in school at Alabama,
Yes.
and so she were to wind up in Druid's emergency room?
Sure.
Would I have any right as a parent or is there anything I could do from
Yes.
Birmingham
Yep.
for her with that document?
Yes, and at that point, those are a couple of those specialty things that we put in there, those special powers that aren't going to be on the state form that you might pull off of. And I'm not demonizing Rocket Lawyer or anything like that, but having a professional look at it, this is the value add to it. You want to have those FERPA type powers to allow them to have access to their on-campus goings on, but also for healthcare reasons, you can put a healthcare section in there that allows your loved one or whoever you name as your agent under your power of attorney to have access to your under HIPAA, to your medical records and things like that. So that document is kind of a one size fits all for an individual who may not have an estate to pass on, but who still has goings on of life. For example, they still are going to need to go to the doctor. They still are going to need somebody to make their appointments for them. Mommy, please call such and such. I don't know how to make an appointment. Okay, daughter, let's sit down and we'll do that with you. Those type of things, but also the things that, for example, there's student loans and all of those things. You need a helping hand. I mean, gosh, I'm 30 years old and I still, student loans still boggle my mind.
Right.
So having someone there as just another person to help guide you and advise you through that, it's never a bad idea.
Okay, so let me ask you, I'm going to complicate this one step,
Let's
and
do it.
I'm going to talk about Cassidy specifically.
Sure.
So Cassidy's mom and I are very cordial, but we're divorced.
Right.
So Cassidy is an adult.
Sure.
But she has two parents who love her very much and who take care of her and all that sort of stuff.
Right.
Would we be on this document together, or would it be one of us, or would she have two of them, or is that a totally different conversation?
So great question. It is something that you see very often with people. My parents are divorced.
Right.
That would be a conversation that I would have with somebody, the college age, my age, whoever, and say, okay, I know you love your parents equally, but which one is better suited for this role?
Okay.
It doesn't, we're when we have these conversations about who's going to step in, I tell people it's not an honor, it's a job.
Right.
So you want to name somebody who's qualified for that job. And I love my father dearly, but he cannot watch me get stuck for any sort of medical test.
Right.
He's not going to be my medical proxy.
Okay.
So I would name my mother if my husband can't do it. So there's always somebody who's more fitted to a position than another. So in that case, I would probably have her guide her towards the person first being the most suited for that job.
This is a great conversation and something we can talk about a whole lot more, but we have a lot of clients that are in this situation.
Absolutely.
And I wanted to bring it up because it's something that a lot of times we don't think about.
Right.
Because when we think about estate planning, we're talking about wills
right.
and things like that.
Right.
These are the nuances of financial planning, of estate planning,
exactly.
of that last puzzle piece that many times we don't think about until it's too late.
Right.
So let's talk about the last document, and that's a medical directive.
Yes.
Here's my question for you. Is this more than a do not resuscitate?
Oh, absolutely.
Okay.
And one of the biggest things that we come in talking about when we talk about the medical directive is, are you familiar with a living will? Because many people have heard about that, due in large part to the early 2000s case of Terry Schiavo, and that whole sad situation where she did not have a living will, and it became it moved from a private family issue to Capitol Hill. So they're probably familiar with that document, but there's a big misunderstanding because we don't talk about these things in high school and college, anywhere really outside of our offices, where people aren't really sure what the difference between a DNR, a do not resuscitate order, and a living will is. A DNR is a document that must be prepared by a physician. So that's a physician document prepared in the hospital for you. So I can't do that document for you. I don't have a medical degree. I have a JD, but it's not an MD. And then I can prepare on your behalf a living will. That is a document that is a state form you must use the state form. This is one of those that is going to look standard from attorney to attorney, from facility to facility, because we don't want doctors in the thick of it looking at a document and going, why is this in 16-point font, Calibri, wingdings? You want a document that a doctor has looked at before and can see, oh, this is where this decision is going to be found. So a medical directive versus a DNR is going to be a document that you sit down with your attorney and you prepare that goes over your wishes for end of life care. So that is a document where you can specify the types of treatment and care that you want should the worst happen. When you are unable to speak for yourself, two different physicians have determined that there is no reasonable hope for recovery for you. And then you can specify in black and white how you want to be taken care of at that point.
Wow. Okay. So the other thing that you and I talked about is it can have you're naming the person
Yes.
or persons
Yes.
that are making that on your behalf,
Right.
and it will talk about things like organ donation,
Correct.
and things of that nature. And I know a lot of time in a lot of states, your driver's license can also have
Right.
that.
Right.
Let me ask this, and we're going to wrap up with just a couple of real quick things.
Mhm.
If I have lived in, say, Pennsylvania
Yeah.
for my whole life,
Right.
and I had a career there, and I'm retired, and I've now moved to Alabama to be near my children and my grandchildren.
Sure.
That's very common
Sure.
that people will move
Absolutely.
around. And all of my documents were created in the wealth preservation phase
Sure.
when I was in my 50s.
Right.
And now I'm, 65. Because I've moved to Alabama or because I've moved to any other state,
Right.
do I need to have those reviewed? Does it really matter from state to state?
That is a great question. And that is one of the things that precipitates a lot of people picking up the phone to call is when they have a major life event like that. And that is the point where it is never a bad idea to have an attorney review your documents, because odds are you've probably forgotten what they say. And they probably, your wishes have changed in those period of years. As long as, let's say, for example, that Pennsylvania resident, now Alabama resident, comes in, they don't want to change a darn thing. They're very simple estate plan. This is how I want to leave it. Nothing's changed. Everybody who they've named is alive and are still willing to serve. We don't have to change it just because it says Pennsylvania if the Pennsylvania law has the same requirements for a will that an Alabama will does. Now, Alabama is unique in a lot of ways, but not necessarily in their will requirements. Alabama has only a handful of requirements to be a valid will. So if that Pennsylvania will checks all the boxes, we're going to be fine. Same for a power of attorney, a Pennsylvania power of attorney. Only a couple of requirements for that to be valid. I will say if you've got a Pennsylvania advance directive, no good in Alabama. So
Okay.
you're at least going to want to redo that document if you have one. I will also add, I know we're running short on time, but I have to add this in here. Your advance directive, that one is your advance directive and your power of attorney. You're going to want to at least, even if your will stays the same, keep those updated about every 3 to 5 years, at least every 10. And that would be because you want the date to be within 10 years, because those institutions who utilize those aren't going to be law firms. They're going to be hospitals and financial institutions, and they may consider those stale at that point. So
Okay.
they may look at those documents and say, there's no way this person just forgot to update them. We on this face are going to say, we don't think this is probably what they wanted. They've just forgotten. So you want to make sure that even if you come in for a checkup, we're going to probably have you just re-sign your powers of attorney and your advance directive to make sure, yes, doctor, yes, banker, this is what I still want.
Right. And that's something that we do at CMC as we review estate plans and we
Right.
review your financial plans. We're looking and we're keeping up with
Right.
these documents as well, making those recommendations. Alex, is there anything, and I know we could go on for hours, but is there anything on the big surface that we think we do want to make sure we get out? I guess, I was just thinking of this as I was asking that question.
Yeah.
Because I glanced and I saw beneficiaries.
Yes.
I'm going to encourage everyone,
Yes.
always, please, 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 when you have a life event,
Yes.
check your beneficiaries.
Absolutely.
I am actually in the middle of an estate plan right now. It's in probate. A beneficiary was named. It was never changed. So the ex-wife is going to get a lot of money. There is not a whole lot that can be done. Am I correct on that?
You are correct.
Okay.
There are certain things that have kick-out clauses, but there are certain things that do not. So you'd never want to leave it to the defaults per chance. It's the same with your will. There's a default estate plan. It's probably not what you want. So the thing I'll say is your professionals, whoever you get involved, we prefer you work together, that we all sit around as a team and talk about it, because just as I was saying at the beginning, your will spans every area of your life. That includes your finances, your arena, your day to day. My favorite is when I get to talk to the financial advisor, the accountant, all of those people within your life who have helped you along the way, who you may see more frequently than me, to have a conversation of, this is how this document is going to fit into their lives.
Right. So, Alex, if someone wanted to get in touch with you, how would they do that?
Great. So thanks for asking. I am always welcome for you to pick up the phone at any point in time. I love to have a chat about what we can do for you. So you're welcome to find me I have a direct dial, and we can absolutely go over that. And then we also have my email, or at dfhlaw.com, DominicFeldHydeLaw.com. My profile and information are all up there as well.
Perfect. And we will make sure all that's in the show notes. And for us at CMC Financial, my direct number is 205-510-9074, cmcfp.com. As always, we're on all the socials: Facebook, LinkedIn, Instagram, and now YouTube. So, RJ, that's all we had today, because I think you're going to make us not go on for 3 hours. So,
yes,
I would.
I was sending you messages. Weren't you getting the message? I'm just kidding. I'm just kidding. I was not. No, it was very informative and important information that everyone needs to have. So, yeah, it might have been long, but there was a lot of good stuff in there. So thank you for listening to the Financial Puzzle Playbook podcast. We ask you to share this podcast, rate it, and leave a review, because this actually helps others find the show. Again, thank you for listening. And for everyone at Financial Puzzle Playbook, I'm RJ Malik, and we'll see you at the next podcast.
Thank you for listening to the Financial Puzzle Playbook. Click the follow button to be notified when new episodes become available. Don't forget to follow us on social media by checking the links in the description. And contact us today by visiting our website at www.cmcfp.com, or give us a call at 205-510-9074. Content here is for illustrative purposes and general information only. It is not legal, tax, or individualized financial advice, nor is it a recommendation to buy, sell, or hold any specific security, or engage in any specific trading strategy. Results will vary. Past performance is no indication of future results or success. Market conditions change continuously. This commentary reflects the personal opinions, viewpoints, and analyses of CMC Financial. It does not necessarily represent those of RFG Advisory, Private Client Services, their clients, or their employees. This commentary should not be regarded as a description of advisory services provided by CMC Financial or RFG Advisory, or performance returns of any client. The views reflected in the commentary are subject to change at any time without notice. Securities offered by registered representatives of Private Client Services, member FINRA SIPC. Advisory services offered by investment advisory representatives of RFG Advisory, a registered investment advisor. Private Client Services, CMC Financial, and RFG Advisory are unaffiliated entities. Advisory services are only offered to clients or prospective clients where RFG Advisory and its representatives are properly licensed or exempt from licensure. No advisory services may be rendered by RFG Advisory unless a client agreement is in place.